What we're pointing to is in the 80s, before the guidelines went into effect, that it's consistently over 50%. And it looks like, at least for 1 year, it's coming up on 60% of all federal defendants who were sentenced received a probationary sentence. Let that soak into your brain, that almost 60% of people who are sentenced got probation. Because anybody who's practicing in federal court right now who doesn't know that statistic, their head just exploded.
From the very moment a defendant is involved in this system, someone else has control over their story. They want to define that person solely by the crime they may have committed. You have a sentencing date set, and the stakes are high. Both lawyer and client need to do everything in their power to prepare. But the question is, are you ready? I'm Doug Passon. I'm a 25-year defense lawyer, a sentencing consultant, and an award-winning documentary filmmaker. In Set for Sentencing, I'm going across disciplines and outside the box to help both lawyer and client expand their perspective, build on their skills, and get real results in the form of significantly reduced sentences. All of this in service to one goal: to bring more fairness, more compassion, and more justice to the sentencing process. So, are you ready? Then let's get set for sentencing.
Hey everybody, Doug Passon coming to you from Studio 3553 in Scottsdale, Arizona. Boy, oh boy, if you've been listening to this podcast, you've heard many a conversation about the United States sentencing guidelines. And you've heard me talk about how deeply broken or flawed or unfair or not empirically based or dehumanizing, just flat out foobard, that's a legal term, Google it, that those guidelines are. But the good news is there may be some fixes on the horizon. So helping us get set for sentencing again in an unprecedented doubleheader, we had to bring back all-star Mark Allenbaugh to talk federal sentencing. Last time he was on the podcast, it was live from Paris. This time, apparently it's Reykjavik. And my goodness, I wish I had your life. But welcome back, Mark Allenbaugh. How you doing?
I'm doing quite well, Doug. How are you?
I think you are doing quite well. Yeah. So there'll probably be some traffic going and back. Mark's staying at Airbnb, and it's fine. You could ask them a little bit about their take on the United States sentencing guidelines and see what they say.
Yeah.
It'd be interesting. But anyway, so, maybe I wouldn't ordinarily do a doubleheader, even with an amazing guest like you, but some topics are just too timely to hold off on. And this podcast today is for anyone out there who's really paying attention to the fact that there's finally a working United States Sentencing Commission. It's been a long time since we've had that. How long, Mark?
It's been about 3 years, maybe longer.
So this commission is
it's been longer than that since we've had a full plate of commissioners.
Right. And so we have them, and what they do is, if they're functioning normally, which it appears we are again, they come out with a list of priorities for this amendment cycle. It's a 22 to 2023 amendment cycle. So they're soliciting. They publish a list of priorities, and they're soliciting comments from the public that are due on or before October 17th, 2022. So it's important, it's timely, and it's kind of a big deal. So we wanted to get this going so you guys can understand what's happening. And then if you feel so inclined, to put some comments in there, because this is really, 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 really important. So before we get to the priorities, I wanted to just give people a background, because we do have people that listen to us that may not know what we're talking about. If you're watching on the YouTubes, if you're not, maybe go there. But here's a visual aid. I'm holding up this big fat book, which is a version of the United States Sentencing Guidelines. The Sentencing Commission created the guidelines. The guidelines are sadly still a very important part of what judges must consider at all federal sentencing hearings. And so the way the guidelines work is every single federal crime you could possibly commit, almost every one, is in this book, and it has a specific guideline. And then we talk about what is a person's criminal history, what kind of trouble have they been in the past. And then you go to this magical little chart of numbers that you can see sort of here. And you plug in the numbers onto a grid, and it spits out a recommended term of months in prison, typically, that a person should receive. So the commission's job, as I said, is to periodically review and revise these guidelines and submit amendments to Congress no later than the first day of May each year. So on that note, they're back in action. They've come out with a list of, I believe, 13 priorities that they're looking to fix or change in the coming cycle. Mark and I are going to tackle the ones that really pop out to us as being the real biggies. So we're not going to tackle all 13. Sorry, I know that's disappointing for you sentencing nerds out there, but we'll do more than half. But I encourage anyone who's really interested in this to check out the full list, which I will put a link to in the show notes, which you can find show notes for every episode of Set for Sentencing at the website, setforsentencing.com. So without further ado, Mark Allenbaugh, we're going to just start at the very beginning, a very good place to start. That's from Sound of Music, in case anyone was curious. I'm a little loopy today. I don't know why. It's not even 5 o'clock. I haven't even had my wine. But anyway, let's talk about the first priority for the commission. What is it?
Well, it has to do with compassionate release, 1B 1.13. And
excellent.
This
and so first give us, like, in a sentence, or what is compassionate release?
So compassionate release was actually at the same time that the commission was created by Congress. Congress also told the commission that we're creating you, and we want you to create these guidelines and all this other stuff, but we also want you to take a look at those scenarios where it would be appropriate for a judge to take a second look at an inmate's sentencing. And generally, if the inmate was very old, had spent a lot of time in prison already, or had some extreme health issues and was going to die in prison, or suffering from a terminal illness, or something like that. And the commission kind of looked at that, but it was moribund. Nobody was really, nobody at the commission, and certainly nobody at the Department of Justice or at the Bureau of Prisons, was really pushing that area of law forward. Now, the way it used to be is the Bureau of Prisons, and only the Bureau of Prisons, could move for compassionate release. They would have to look at an inmate and say, this inmate is so sick, we don't want him to die, him or her to die here, or they've served enough time already, they're elderly, or they have some special family circumstance. So we, the Bureau of Prisons, the warden, we're going to file a motion on behalf of this inmate to ask the court, the judge that sentenced them, to take a second look and perhaps release them early, from the sentence for these specified reasons. Well, what ended up happening was nothing. The BOP wasn't doing this. And this whole compassion, and the commission wasn't really doing anything either to encourage the BOP. And that's what Congress had wanted back in 1986 or 1984 when it created the commission. So lo and behold, one of the few things that our former president did quite well was take a look at this. And it wasn't really him, I think it was Jared Kushner and some of the other people that were around him, but they really took a strong look at this and said, we need to do something. We need to change the law here to allow not just the BOP to make these motions on behalf of inmates, but to allow inmates themselves to go into court and say, hey, you know what, Judge, I think you need to take a look. The warden is ignoring me for whatever reason, but I think you need to take a second look at this. And Trump came out with and passed the First Step Act, and that allowed inmates now for the first time since 1986 to move courts for compassionate release. But the problem still remained that there were still very limited grounds that that an inmate could move for compassionate release. And then all of a sudden, right after the First Step Act passed, or shortly thereafter, we get COVID, and that changes the entire landscape. The problem then was that we had no commissioners, and the way that the commission had drafted 1B 1.13, which is the part of the sentencing guidelines that has to do with compassionate release, the way they drafted it was prior to the First Step Act, where they made it apply only to, it basically defined what policies or what grounds a warden could move for compassionate release. The commission never looked at what grounds an inmate can move for compassionate release. And
because they weren't allowed to.
Because well, they couldn't, because they no longer existed. The commission basically died. I mean,
Yeah.
it didn't die, but it didn't have any commissioners anymore.
Well, I'm saying, but they didn't look at the grounds an inmate could request release, because
right,
the inmates
right,
weren't allowed. Only the wardens were up until
right. Only
First
the
Step
wardens
Act.
were allowed.
Yeah.
So this created all sorts of confusion in the courts, where some courts were saying, well, 1B 1.13 says you can only look at medical issues, age, and family circumstances. Those were the three. That's it. You can't look at anything else, like changes in law or anything else. That's it. Just those three, or rehabilitation or anything like that. And some courts said you could still only look at that. And other courts said, you know what? The way this is drafted, it only applies to wardens. It says what the wardens can consider. It says nothing about what inmates can bring. And so some courts opened up floodgates and said, look, inmates can try to establish it, and courts can consider anything as an extraordinary and compelling circumstance for compassionate release. And that created a split in the circuits, which is kind of concretized now, where there's only really one big split, and it has to do with the 11th Circuit. The 11th Circuit still says you can only look at those traditional three things, but all the other circuits say that you can look at everything. What the commission now is going to be able to do is not only to resolve that circuit split by saying what you can look at, but what they're talking about is looking at expanding this, not just the health of the inmate, not just the age, and not just family circumstances, many other things. And frankly, the commission's listening. I think the best way is also to have kind of a catch-all, where a judge give the judge the discretion to consider anything as an extraordinary and compelling circumstance, because frankly, anything could be in combination or singularly that may have nothing to do with the inmate's health, the inmate's age, and with the inmate's family circumstances on the outside. So this is very important for the commission to take a look at, and it's something that the commission really has never looked at seriously and in depth since it was created. So, and this could help alleviate.
And I think I'm sorry, I didn't mean to interrupt, but I think that's where I was going too. I think if the stated priority, if it's true to reduce the prison population, then we should have a catch-all, and we should make these, give an opportunity to put forth any meaningful, credible argument that would warrant early release. So, okay, so that could be very important. And a little more background, I think, just for someone who's coming to this, the novice, because you brought up this date of 1986, that's when the guidelines actually went into effect.
November 1, 1986. Yes.
So that's important. I think that's important for people who don't know to understand. There haven't always been sentencing guidelines in the life of federal criminal law that in the grand scheme of things, they're relatively new. So before 1986, it was just, what does the statute say is the maximum you can get for this crime? Is it 20 years? Is it 50 years? Is it life? And then the judge has the option to do anything from probation up to life in prison, unless there were mandatory minimums, but I don't know how many of those existed in the 80s either. So, but then, basically it was anything goes at sentencing. They thought maybe there was racial disparities or things. So they thought the judges needed to basically have these guidelines, and they were more than just guidelines. They were almost the law. Like basically you couldn't deviate from these guidelines, but for the most extraordinary circumstances. And then, not to get too in the weeds, but flash forward to 2005, the guidelines became discretionary. The handcuffs came off the judges. They had more leeway. And these are just now what we call advisory guidelines. So they give advice to the judge about what the sentence should be. And in most cases, the judge is free to disregard that advice and go lower or higher.
Right, and that goes to 3553A. The judges can consider anything when they're imposing a sentence. So why can't they consider anything when they're looking at compassionate release? It's logically
100%.
consistent. It's logically consistent. And this is what the commission needs to clarify and allow judges to do, is to judge. And I would just note one thing though. One of the things though that we know at sentencing is judges are to consider unwarranted disparity. In other words, I mean, one of the goals of the guidelines when they were mandatory, but still even in their advisory fashion, is to treat similarly situated offenders similarly in terms of whatever punishment they receive. But that also has to be the case for compassionate release as well. And one of the factors that I think the commission should encourage judges to consider is what sentence was imposed originally. Maybe for whatever reason that judge hammered this particular defendant, but hammered the defendant without realizing that he or she was hammering this defendant because they didn't know the statistics. They were just looking at the guidelines. And in our post-Booker world after 2005, especially depending on that particular guideline, judges are varying downward at an increasing frequency and an increasing magnitude.
Yeah.
So now, a judge might look at somebody, maybe they sentenced 10 years ago to 20 years, and that was kind of consistent. But that same defendant today would only get maybe 5. And that's something that a judge should consider in terms of compassionate release. That maybe, you've served enough time.
And it is going to be interesting to see how if the floodgates open fully, because it's very difficult. This is something lay people might not understand either, but it's very difficult to get a second look after your conviction is final and you don't have a right to appeal and your 2255 time limits exhaust. Basically, this does give us a mechanism to go back and make an argument. Like I did one not too long ago where I read the sentencing transcript and he got abysmal representation at sentencing. Yeah. Like it was clearly ineffective. There was virtually no mitigation presented at all. And I said that in and of itself is worthy of a second look, because if you would have had competent counsel to present you with this information, this mental health issue, this life circumstance, this good deed, whatever it may be, judge, you might not have sentenced this dude to that much time in the first place. So it'll be interesting to see if that catch-all does come into play. Is it open season? Will there be a limit? And I think,
well, why wouldn't it be open season? Why? What's the problem if it is? I mean, some might argue that we're just creating we're creating a parole, a de facto parole. But the compassionate release has always been there. It's always been there. So it's nothing that's being created. It's being defined and refined. Yeah.
Now, because we're a couple of liberal commie pinkos, we don't have like a prosecutor on here right now to talk to us, which, I'm sure we could find one. But here's the flip side to this is finality, which is the bane of my existence. And especially in these cases where wrongful convictions happen and people are rotting in prison for the rest of their life. But the other side, if you ask why not have the sky's the limit, the other side would say because there needs to be finality in this process. And I say to you, and I had David Rudolph on the podcast early on, amazing lawyer from The Staircase, and he wrote American Injustice, which is just a litany of wrongful convictions. And he said, that is the main reason why things go wrong in our system is because of this so-called need for finality, that once it's done, it's done. Right. And so that is something we need to be done with. Finality. Right. Yeah. Finality for finality's sake is a purposeless maxim. Right. Anyway, wow, we just spent a long time on number 1. So I think this could shape up to be our longest podcast in the history of the universe. But let's move on to the next priority, which I have on my list. We're going to actually skip down a few. This is about resolving circuit conflicts. What is a circuit conflict? Well, it's basically where 2 different circuits, we have 13 circuits, 11 circuits, the DC circuit plus the federal circuit, which doesn't do any criminal stuff. So really just 12 circuits with respect to criminal law. And each circuit could develop its own interpretation of the guidelines. And like I kind of referred to one earlier, there's a circuit split, meaning one circuit is reading the guidelines one way and other circuits are reading it another way.
So a circuit split, just as an example that I referred to, has to do with compassionate release. The 11th Circuit, which is down the southeastern states, says that you can only look at the 3 classic reasons for granting compassionate release. And all the other circuits, literally all the other ones, say, no, you could consider anything. So there's a circuit split, and that's what the commission is designed to do, is to alleviate. We want uniform federal law throughout the land. They kind of act like the Supreme Court in that sense, which reminds me of Scalia's reference to the Sentencing Commission as a junior varsity Congress. But at any rate, that's something else.
Well, that's what I was going to ask, because oftentimes the Supreme Court is called upon to resolve a circuit split. So
All the time. That's
how
what they do.
How does this gel with that? This is if the Supreme Court hasn't decided the issue or has refused to decide the issue, then it goes to the commission.
Yeah, well, sometimes the Supreme Court might decide the issue, and the commission can disagree with it and revise the guidelines accordingly. The commission isn't beholden to however the Supreme Court interprets the guideline. The commission can always change the guidelines. The only check that the commission has isn't so much the Supreme Court; it's Congress, and Congress is what can nix any amendments to the guidelines. But the commission, just like the Supreme Court, but the Supreme Court tries to resolve circuit conflicts among all areas of law: civil law, criminal law, administrative law, all this other stuff. The commission is just focused on federal sentencing guidelines law, and it's trying to resolve these circuit conflicts so that, frankly, that the Supreme Court doesn't have to bother with it.
And you were a staff attorney on the commission way back
Correct.
in the day. So in your experience, if Congress is the ultimate check on the commission and they have to ratify these, for lack of a better term, have you ever seen a situation where Congress says no and shuts down?
Yes, it's very, 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 very rare. Out of the 800 something amendments to the guidelines, I think only 3 times has Congress. And by the way, the Congress doesn't have to ratify. Congress just has to do nothing. As long as Congress does nothing, then within 6 months, so the commission commission submits its amendments to the guidelines on May 1. If Congress does nothing by November 1, then those guidelines become law. Basically, they go into effect. But if Congress does something, which they've done only 3 times, and they reject them, then those guidelines do not become they don't have the force and effect of law, so to speak. They don't become effective. And when Congress has objected to amendments, it has to do with mandatory minimums with the drug guidelines, where the commission had in the past tried to change the ratio between crack and powder cocaine to make them more equal and less disparate, because there's always this huge disparity between crack cocaine, how it was treated, and powder cocaine, which had an inherent racial disparity to it.
Yep.
But that hasn't been eliminated, but it has been alleviated. During the Obama administration, there was some legislation that helped reduce the disparity between those two.
Mm-hmm. Mm-hmm. Okay.
But generally, Congress lets the commission do whatever it wants. Okay. But also, I just add this one part.
Yeah.
Congress also does what are called congressional directives. Sometimes Congress tells the commission what it must do, and the commission must do that. Congress will look at, pass a new law, make a new crime for something, and say, look, we have this new crime, XYZ crime, and we want the commission to create an upward adjustment of 2 levels for this, that, and the other. And the commission has to do that.
So priority of resolution of conflicts, we should talk about what circuit split, what conflicts there are. The guidelines list a couple. I just want to focus on the first one, and it's whether the government may withhold a motion pursuant to Section 3E 1.1, which is the acceptance of responsibility guideline. So talk to me like I don't know anything about the guidelines, and tell me what is this acceptance of responsibility you speak of, Mark Allenbaugh?
Right. Well, the acceptance of responsibility is a built-in downward adjustment of 2 to 3 levels to incentivize defendants to plead guilty, as opposed to going to trial. And it's generally always given, except in very rare cases when a defendant pleads guilty. The only times it's not given is when there's obstruction of justice, something like that involved in the offense conduct. The problem, though, it has become is sometimes defendants have they will plead guilty, but sometimes they'll do what's called a conditional plea. And Rule 11 allows you to do a conditional plea. And what a conditional plea is, says, I'm going to go ahead and plead guilty, but I reserve the right to make some evidentiary challenge, like a motion to suppress or something like that, because I believe my Fourth Amendment rights were violated on a search or something along those lines. So I'm gonna go ahead and plead guilty, but I want to test this legally, which is really a separate and apart from whether or not I'm guilty. And I want to test this, and if the court agrees that my constitutional rights were violated, then I get to withdraw the plea. What has happened, though, over the years is some U.S. attorneys' offices say, look, it's all or nothing. You're either going to accept responsibility, and that's the end of it, even if there is a constitutional violation. Others will say, look, if there is a constitutional violation and the court agrees, then fine. You can withdraw your plea, or the court doesn't agree. We'll still give you acceptance of responsibility, because we understand that your constitutional challenge as a procedural matter is different from whether or not you accept responsibility for your offense conduct. And we're still going to afford you to exercise your constitutional right, or to see if your constitutional right was violated. So it's basically whether a defendant really what it is what constitutes acceptance of responsibility. Is it just waiving everything? And even if you might have a colorable challenge to some search and seizure issues, some Fourth Amendment issue, you have to waive all of that too, even if the search was illegal and that your plea is developed from essentially illegal evidence, but you agree not to contest it? Or is it that you will be allowed to contest these issues and will still grant you acceptance of responsibility?
Okay.
So that's really what the circuit split. Yeah.
Okay. So
what constitutes acceptance? That's really what the commission has to articulate for the districts. Is does acceptance mean waiving everything, or does acceptance can you still receive acceptance of responsibility for raising a procedural challenge to your conviction?
Yeah. And to me, this feels like an argument that's about the power of the prosecutor and about coercive plea bargaining, so that we give a lot of power to the prosecutor to all along the way, but in this instance, to determine what the plea is. And some prosecutors are like, you're either going to take this plea or not. But if you file a motion to suppress the evidence because the police, kicked in your door without a warrant and found this gun in your house or something, then you're going to lose what we call acceptance of responsibility. So you're going into sentencing saying, yes, I'm guilty, but there was a violation of the Constitution. I'd like to be able to challenge that still. And some prosecutors say, too bad, no. And exactly. So this is about their power, I think. So that'll be interesting. Okay. Yes. So the next one on the list is says, well, tell me about this. In light of I'll read it. In light of the commission's studies on recidivism, so my ears are already perked up. Consideration of possible amendments to the guidelines relating to criminal history to address A, the impact of what we call status points, and B, the treatment of defendants with 0 criminal history points. So before we dig into that, again, just for the benefit of people who don't do this work every day, all day, criminal history is part of that matrix that we discussed. And what it is just, if you've ever been in trouble, it probably counts for some kind of criminal history points. You either get 1, 2, or 3 points, depending on how old the offense is, how much time you did on the offense, and that sort of thing. And they add those points up. And if you go back to this matrix, the dreaded matrix chart, it goes up to farther and farther to the right, which increases the guidelines higher and higher up. And so, and then there's also these status points, which I think, if I'm correct, refers to if you committed the instant offense that you're being sentenced to, and maybe you were on probation or parole or some kind of supervision for
Correct.
another
That's
offense.
exactly correct. Yes.
Or what's the other one? The within I can't remember. Is that the
Well,
only one?
including, it's probation, parole, supervised release, imprisonment, a work release, or escape status.
Okay.
That's what.
So you get two extra criminal history points for that.
Two
Those are what
extra
we call
criminal history
status points. So
Yeah.
let's break this down though, because this priority that the commission sets forth starts out in light of the commission's studies on recidivism, consideration of ... So do you know if the impetus for this closer look is studies on recidivism? Do you know what they're looking at and what those studies say that actually puts this on the radar?
Well, yes, they're looking at criminal history, and is there a correlation between criminal history, not necessarily writ large, but certain types of criminal history, and the correlation for future recidivism? So, if you're happen to be a drug offender or something like that, and you have so many drug offenses in your past, what's the likelihood that you're going to commit a drug offense in the future? That's basically what they're looking at in terms of these recidivism studies. And I mean, it's not. There's nothing very surprising about this. Is the more an offender has, the more criminal history an offender has, the more likely this offender is going to reoffend in the future, writ large. There are other factors that come into play. Sex is a big one, or gender, whether the defendant is female or male. There's a huge difference in terms of recidivism between males and females. With males, males commit most of the offenses, and they also recidivate much more than females. Age is a big factor. Younger offenders tend to recidivate more than older offenders, and the commission has done many studies on this to show that. And there are other issues involved too, in terms of what types of offenses. So, for example, like white collar offenders, you don't see a lot of recidivism with white collar offenders, because generally, once a white collar offender commits a particular offense, they might be barred from ever being a director for a company again, or holding any kind of position of authority at a bank, for example. So they may have committed like a bank fraud in the past. Now they're not going to be able to, by virtue of the fact that they have a felony conviction. So that kind of removes their ability to commit certain types of offenses in the future, whereas that might not be the case for a drug offender or an illegal immigration offender.
All right, so they're looking at the treatment, how to treat defendants being sentenced who come before the judge with 0 criminal history points. And I will say, as a commentary, this has always been a B. I've always had a bee in my bonnet about this, because the guidelines only allow for increases if you do have criminal history, but they never allow for a decrease if you don't. And so they never take into account, at least in the criminal history category, the fact that you've never been in trouble before in your life. What is that worth? So what do you think is going on there, as far as, like, what are they contemplating there?
Well, what they're contemplating, if and forgive me for stealing your thunder, is if we look at consideration number 8, and that has to do with 28 USC 994J. It's a statute that's been in place since the commission was created, and what that statute says, it was a directive from Congress to the commission to devise or develop the guidelines in such a way that first-time nonviolent offenders generally would not receive any type of custodial sentence. So just let me read this to you real quick. So this is 994J. From the Congress, back in 1984, and it became effective in 1986. The commission shall ensure that the guidelines reflect the general appropriateness of imposing a sentence other than imprisonment, so that could be probation or home confinement or a halfway house, in cases in which the defendant is a first offender who has not been convicted of a crime of violence or an otherwise serious offense, And it's not defined in here what an otherwise serious offense is, but we can imagine, for example, what an otherwise serious offense is. So it could be like a fraud of several $1,000,000, or it could be a child pornography or sex offense or something like that. And the general appropriateness of imposing a term of imprisonment on a person convicted of a crime of violence that results in serious bodily injury. And that's really the focus here, is that there should be a default, according to Congress, not the commission, Congress, that there should be a default of imprisonment only for one class: crimes of violence that result in serious bodily injury. That's where prison should be a default. But really, the way the statute's written, anybody else, there should be a presumption for a non-custodial sentence.
All
and this
right.
might be a
So
good point.
Yeah, let's break this down, because
Yeah.
you've heard the old
Yeah.
saying, like, don't make a federal case out of it. In my experience, and now I started federal practice in the late 90s, so the guidelines were already there. But you, in order to fulfill the mandate of Section J, which is a default to probation, there's no such thing as a default to probation in my experience under these sentencing guidelines. That probation is a rare animal in there. Now, we'll call back to our earlier discussion. There's life in federal court pre-1986, when the guidelines were enacted, and post 1986, where the guidelines are supposed to take this into account but don't. Tell me, like, do you know what life was like pre-1986 for federal defendants coming into federal court?
Well, I'm glad you asked.
Thank you.
Because I do. Because I do. So let's take a look.
What a surprise.
What a surprise. Yes, it's shocking. So this is from an unpublished law review article I was working on a few years ago.
And by the way, for anybody listening on the podcast, I'm so glad you're listening, but there's a beautiful chart with lovely colors, and you're not going to be able to get the full flavor of this chart unless you go over to YouTube and search Doug Passon and Set for Sentencing and pull this episode up on the YouTubes, so you can see this lovely chart, because Mark is famous for his lovely charts. And while you're there, smash that subscribe button. Okay, go ahead.
Okay. Yes, I love charts. So this shows what the evolution of sanction type, whether the sanction imposed was imprisonment or probation, or some type of split sentence between probation and home confinement, or halfway house. And what we can see here, this orange part shows what percentage of federal sentences were straight probation since 1980 through 2016. And you could see that the majority of sentences were probationary. That was really the default.
Wow. So if people aren't at the YouTubes, just statistically speaking, what we're pointing to is in the 80s, before the guidelines went into effect, that it's consistently over 50%, and it looks like, at least for 1 year, it's coming up on 60% of all federal defendants who were sentenced received a probationary sentence. Let that soak into your brain, that almost 60% of people who are sentenced got probation. Because anybody who's practicing in federal court right now who doesn't know that statistic, their head just exploded.
Yeah. And then
what's it like today?
Well, we see a marked change in 1984. Okay, that's when the Sentencing Reform Act passed, and it became effective in 1986. And we could see now a significant drop in just straight probationary sentences, but nonetheless, there was still an allowance for so-called split sentences, where it wasn't all prison. And so, through, it looks like up through 1989, still at least half of all sentences were probationary or split sentence. They still weren't defaulting to a custodial sentence in prison. And then it just skyrocketed, or it fell off. Probation just basically disappeared. And we could see it just went consistently down and down. 1994, we had the Crime Control Act passed, and that introduced more offenses and incentivized the commission. I think it actually directed the commission to essentially send more offenders to prison. And that's exactly what we see. We see that the evolution of the sanction type went from probation to all this blue area here to imprisonment, where now, as of last year, according to the U.S. Sentencing Commission, almost 90% of all offenders received a custodial sentence. There was no split sentence. There was no probation involved. They went straight to prison. And very few inmates now, or very few offenders, are receiving any type of alternative to sentencing or alternative to incarceration, which is causing the BOP's population, the inmate population to grow just incredibly. It's skyrocketing once again. Right now, the BOP is about 25% over its rated capacity, and it's closing in on its PREA capacity. And we won't go in. We don't need to go into that. But the point simply is that the default is now custodial sentences, imprisonment, which is leading to just an explosion in prison population, which is really bad, considering that we're still within the pandemic with COVID-19, and all the private prisons, except for one, now is closed. All the private prisons, there was 14 when the Biden administration came in. They have all closed except one, and all those inmates have been transferred into BOP facilities, which has contributed to the explosion.
And so, forgive me if I missed it. So we talked a lot about the pre-sentencing, the percentage of people getting probation before the guidelines. Yes. Just give me like 2021. What are the numbers look like today for the amount of people getting probation? Does it say?
Well, I'll tell you, it's worse than this. It's worse than what it's shown here. Only 6.2% now are getting straight probation.
All right, so we're looking at a chart again for you listeners. Fiscal year 2021. If you could see this, it's a pie chart this time. Lovely pie chart. The sea of red is prison only. 88.4% of people sentenced went to prison in 2021 fiscal year. And this little teeny blue sliver of probation only cases that got probation, only probation, 6.2%.
And as we discussed, Doug, most the plurality of those defendants are low loss, first time economic crime defendants. Mm-hmm. And the majority of them are either low loss economic crime defendants, immigration defendants, or offenders, I should say, or low level drug offenders.
Yeah. And I guarantee you, in that 6.2% sliver, there will be what we would call violent crime, the people that didn't meet the presumption for whatever extraordinary circumstances exist in their cases. Right. Sometimes probation is the right result, even in serious cases. But the takeaway is, for non-serious cases, non-violent cases, we should be getting probation sentences.
Right.
Way more than we do. So I think part of the problem here is first of all, a big part of the problem is nobody even knows about Section J.
Right.
That we should be, there's one takeaway for defense lawyers or anybody listening, we should be screaming about Section J, so 28 USC 994J. We should be screaming that from the rooftops to basically say, look at what we're supposed to be doing. We're not doing it. Why is that? And then we have to tackle this other issue that it says, okay, if it's not a violent offense, or what the statute says, an otherwise serious offense, what the F does that even mean? And how do we take that and argue that, this is not an otherwise serious offense when there's no definition for it?
Right. Exactly.
And I don't know, but what I do know is we basically treat almost all offenses as serious, and that's wrong. And that needs to change, and I hope the commission figures that one out.
Well, and if I might share one more screen with you,
please.
And I know we just talked about 994J, but we also need to talk about 994G. And I've kind of highlighted here in the gray. This is from this 28 USC 994G has been in place since the commission existed. And this sentence has consistently been completely ignored by the commission.
Okay,
Now,
read that sentence for us.
The sentencing guidelines, this is just part of J or G, it's not the entire part, but the sentencing guidelines prescribed under this chapter shall be formulated to minimize the likelihood that the federal prison population will exceed the capacity of the federal prisons as determined by the commission. Commission's never looked into this. Now, in all fairness, every time that the commission has promulgated amendments to the guidelines, it will do a prison impact analysis that nobody reads, that it doesn't promote, that the commission doesn't promote, that the commission doesn't seem to take, at least officially, into any consideration when it's promulgating amendments to the guidelines or responding to congressional directives. And this is something that hopefully the commission will now look at in conjunction with its assessment of what type of offenders should not receive, or where the default sanction should revert back to probation, the way it used to be prior to the guidelines. And obviously probation means you're not putting inmates in prison. And why don't you go ahead and talk a little bit, and I could
well, as you touched upon for a second, a few minutes ago, the heart of that last provision there in subsection G is the point of this is not to exceed the capacity. In other words, we're trying to reduce overcrowding in the federal prisons, and what you're saying is that goal is way out the window, that every single federal institution exceeds their rated capacity sometimes.
Well, not every single one. So let me just I'm going to share one more with you here. Just another chart. I like charts. They can make my point much better than I can. So what this is showing, there's 198 BOP facilities right now throughout the United States. And as of last week, 94 of those 190, or almost half, were over their rated capacities. And this is just basic. What this is a trend chart showing all 190 facilities since the end of July 2020 and where they're at. And all the gray lines above this red line indicates that particular facility is over its rated capacity. The average has increased from 94.8% to 104.9%. It's increased over 10% over the course of the pandemic. Now, I'm going to show you one other slide here. Can you see this one that says weekly overall inmate? Okay.
Yeah.
So if you just add up all the rated capacities, of all 190 facilities, you can see that as of last week, there are over almost 15,000, actually over 15,000 over the rated capacity overall. The number of inmates, and they're bumping up on their PREA design capacity. And again, we don't need to get into exactly what that is, but it's basically,
I'll tell you
two danger points.
Prison Rape Elimination Act, right?
Right.
Is what PREA is. And
correct.
And this is the human face behind, this is the story behind the stats, Mark, because these stats are important unto themselves, but let's think about the reality of the implication of these stats. It means prisons are overcrowded. It means prisoners aren't getting the care that they need from the healthcare. They're not getting the supervision they need from the staff. They're not getting the services they need in terms of treatment or work opportunities. It's a pandemic, so they're squeezed in together, sharing each other's germs and stuff. I just went to a federal prison. There wasn't even soap in the soap dispenser in the bathroom for the guests that are coming into the prison. Can't even imagine what it's like behind the gate. And so what this does in the prison rape eliminate, what does that translate to? Well, you got to protect an inmate. You got to keep them safe. And the more inmates are, especially with staff shortages, the less ability you have to do that. So these are real life human consequences.
Yes.
That flow from this data.
Yeah. And so let me show you, I keep saying one last chart, but this for real is one last chart here. This shows you, actually, the population is a comparison of inmate populations by type. where the blue is inmates that are in federal prisons, inside institutions. The blue is the number of inmates that are in RRCs or halfway houses, and the gray are the number of inmates that are on home confinement. And as we can see, they dropped significantly at the beginning of the pandemic. And the BOP, as well as the federal courts, did a great job in conjunction with DOJ in reducing the number of inmates in prisons by a significant amount. But they've caught back up. It's gone back up, and it's gone back up for a number of reasons. One is they're prosecuting at the same rate that they were pre-pandemic. The closure of all but one of the private prisons, and now they're not putting as many inmates in the RRCs or in home confinement as they used to towards the middle of the pandemic.
Yeah, so it's almost right back at pre-pandemic levels.
Correct.
So
it's almost right at pre-pandemic levels.
Business as usual, and that's what's significant about this Sentencing Commission stuff, because there's a common thread running through a lot of these priorities, which is reducing prison population. And if that's their goal, then hats off to them. So let me ask you, I think one of the byproducts of us having this conversation is the hope that anybody who listens will jump on and submit comments. So go on the website. I've got the link in the bio, but like, what do we even, like, what should we say? Like, what kind of, how do we approach this? Especially if we're maybe not a lawyer, we're a family member or somebody who's,
Commission wants to hear from you. Even if you're not a lawyer, you're not a professional, family member, an ex-convict, especially. The commission wants to hear from you. They're looking for input from all actors involved within the federal criminal justice community. And so you have until October 17th to submit comments to the commission. And I think, Doug, you said you were going to post a link on your website.
And, I'm a little bit of the skeptic sometimes, but I like to be hopeful and optimistic. And I believe, the fact that this commission is fully staffed means that this is important to the administration to get this done. I believe that your comments matter. Like, sometimes I think I'm not going to email my senator about this, that, or the other, because it's a waste of time and they get 1,000 emails and they're never going to read them. I don't think that's the case here. I think your comments matter. And you know what else matters? I think stories matter. If you have experience firsthand with this overcrowding or your time in BOP, if their goal is to truly reduce the prison population, then you write them and you tell them your story. You put the human face on it, because that's what moves the needle at the end of the day. We're not done yet, just in case you were thinking that I had wrapped up. What's funny is I thought this was going to be a super fast episode. This might be like a mini thing where we do half hour. We'll just bust through these priorities super fast, but that's never the case with us. And that's okay, because this is important. I'm sure the people at your Airbnb in Reykjavik may be ready for you to get off the call.
They are.
But I'm not I'm not done. You tell them I'm not done with you. Let's see here. So you touched on 8, which I thought was super important. Okay.
Yes.
So now real quick, we can bust through these next two pretty fast and then wrap it up. But number 9, they're going to be considering possible amendments.
This is important. This is very important.
It's hugely important. Tell me about it.
This is absolutely critical. So this is this weird aspect of federal criminal law where acquitted conduct can still be considered for sentencing purposes to enhance your sentence. So what that means is, just take it as an example. You're indicted for 2 counts of wire fraud, and they're both for $100,000. Well, and you're acquitted of one. Go to trial on these 2 counts. One count you're acquitted, the other count you're found guilty of. So you would normally think, well, I'm only going to be held guilty for that $100,000 because each count was for $100,000. So there's no way I could be found. I was only found guilty of $100,000 fraud. So that's all I'm going to be sentenced for. Not under the guidelines, not under the way that the guidelines have developed since 1997, when the Supreme Court held in United States versus Watts, per curiam, that even acquitted conduct can still come in at sentencing, provided there's a preponderance of the evidence to support that finding for that other $100,000. And that's always struck many people, including U.S. attorneys, as very irrational, because if you're acquitted of something, it means you're not guilty, and which means that you're not criminally responsible for that conduct. So how can that conduct now come back in that you're otherwise not criminally responsible for and be used to enhance your sentence? So this is Congress has even taken a look at this. There has been several attempts to pass legislation to preclude the use of relevant conduct. It hasn't gone anywhere. And so I'm glad that the commission is taking a look at this.
Well,
but in my
go ahead. No, please.
Well, I was going to say that acquitted conduct isn't the end of the story, though. What the commission also needs to look at is uncharged conduct or conduct where the charges have been dismissed. So taking my example again, you can still have, you could be charged with 2 counts of fraud, of wire fraud, $100,000 each, but you decide to plead guilty. And you're only going to plead guilty to 1 count. And the government agrees to dismiss that other count. Well, that dismissed conduct can still and does come back in at sentencing. So what's the point then? Why enter into a plea agreement like that? It doesn't help you at all. Finally, I'm sorry, the uncharged conduct is the most problematic because the government doesn't even need to charge you with anything.
Right. They don't have to do
as long as they don't have to do any work. So they have 1 charge for $100,000, and then they can come in at sentencing and say there's all this $1 million of fraud sitting out there too. And you're going to end up getting sentenced for that.
And we see this is not like a hypothetical. We see this all the time, that all this other stuff comes in and it's the tail that wags the dog, and it sends the guidelines through the roof.
Exactly.
But here's the bigger problem, because the simple take, especially with acquitted conduct, is, look, our Constitution says very simply and very clearly, you are presumed innocent unless proven guilty beyond a reasonable doubt.
Thank you.
And if you have been acquitted of conduct, then you're still innocent per our Constitution. Close the book.
Bingo.
End of story. But
Bingo.
then this is one of my biggest beef with the guidelines, and it's not a priority this time, but hopefully next time. The guidelines are in such conflict with this fundamental presumption of innocence in the Constitution, because it says, guess what? That whole beyond a reasonable doubt thing that we need to prove that you're guilty does not exist in the world of sentencing. And in fact, the burden of proof for these other things that you've never been convicted of is what? Preponderance of the evidence.
Preponderance of the evidence.
Which is like 51% for you civil lawyers, right?
Right.
So they just have to show it's more likely than not that this happened, not beyond a reasonable doubt.
And where did that preponderance of the evidence come from, Doug?
That came from the guidelines, right? 6A 1.3.
And where did that come from?
Somebody's a-hole. I don't know.
They made it up.
They pulled it out of thin air.
They made it up. They looked at pre-guideline factors, or the way the courts would resolve factual disputes pre-guidelines. But
let's keep going down the rabbit hole on this topic, though, because it's really is crazy, because we talked earlier about how the guidelines in 2005 were made discretionary because they were so rigid and the judges had such a lack of ability to deviate from them. And what happened was lawyers were saying, and it started even in state courts with the Blakely case, to say we're using this other conduct to enhance these sentences, and that's not constitutional because there's no burden of proof, the beyond a reasonable doubt, and what the Supreme Court looked at this and said, well, that's kind of right. That doesn't feel so good. So rather than fix it by doing what they should have done and say, you must prove all of these enhancements beyond a reasonable doubt, they just said, okay, well, instead, we'll just make these things discretionary so that maybe the judge, you don't have to follow this to the letter if you don't want to. But it's all sort of intertwined in this nasty tangle, this mess. And I feel like in the middle of this ball of tangled threads is that burden of proof, is that burden of, I don't know if you agree with me there, but I
agree with you.
It's
I agree with you,
and it's wrong,
and it is wrong.
And that's my high horse.
And yes, and we have we have the late great Justice Ginsburg to fault for that. She was the only justice that sided with both majorities. She is the one that created both majorities in Booker that said mandatory guidelines are unconstitutional, but we can go ahead and treat them as advisory. She was the one that caused that. And which, by the way, to this day, Booker is the only Supreme Court opinion with 2 majority opinions. The only Supreme Court case with 2 majority opinions.
And let the record reflect, I still love you, RBG. May your memory be a blessing. I mean, we all make mistakes.
We all make mistakes.
You know,
sometimes really big ones.
So that is not listed as a priority, this whole burden of proof thing, but acquitted conduct is. And so that is a great start. So that thank you, Commission, for making that a priority. And maybe next year we'll take it one step further and attack the burden of proof, because that is a big one.
Yes, it is.
Yeah. So, you know, I think we could wrap it up there. I guess part of what I wanted to do was have a conversation about what we really, really wish, what other priorities we wish would have been in there that aren't. But you know, we could save that for another day, unless you have any quick thoughts.
I got a few just real quick.
All right, good.
Okay. In addition to evidentiary standards introduced at sentencing, where maybe some things it's okay for a preponderance of the evidence if we're only talking like 1 or 2 offense levels. But when a particular factor can increase the offense level by 12, there needs to be a higher evidentiary standard for that. And the Ninth Circuit still has clear and convincing for those sentencing factors that are I can't remember the exact terminology, but basically very disproportionate, or substantially increased the sentence. But I think there needs to be evidentiary standards that articulate preponderance, when preponderance is appropriate, when clear and convincing is appropriate, and when reasonable beyond a reasonable doubt is appropriate. And along with that, there should be rules of evidence at sentencing. Over 93% of all federal criminal cases are resolved by plea. And when the defendant not only waives the right to trial, but basically waives the right to the rules of evidence and all these other protections that are designed not necessarily to protect defendants, but to ensure that that reliable evidence is introduced at trial or introduced at sentencing for a judge to consider. And without any types of rules of evidence, and the commission, as well as the judicial conference back in the 90s, did look at this briefly and then dropped it. Nothing ever happened to it. There needs to be rules of evidence and rules of procedure put in place at sentencing, because right now it's a mess. It's anything goes. Every judge has his or her own procedures and all this other stuff.
I think the guidelines will say minimal indicia of reliability. So there's allegedly a threshold, it means nothing.
It means nothing.
I don't know what that means. But here's my pushback. Here's the counter to that, which is it a be careful what you wish for situation? Because in sentencing mitigation, which is my bread and butter, and sentencing mitigation videos and everything else, it's hearsay. And I mean, if I had to conform my sentencing presentation to the rules of evidence, I would be significantly restrained in the kinds of evidence that I could put forth.
Okay, so I mean, rules of evidence for sentencing. I'm not talking about import the rules of evidence that we use at trial and have them apply equally at sentencing. Different animals, different things going on, completely different procedures. So I think the commission can develop, and it doesn't have to be extremely robust, but something to try to standardize the sentencing process. If one of the cardinal rules of sentencing in the commission is that similarly situated offenders should be sentenced similarly, then they should be treated similarly. Then they should have similar sentencing hearings, and they should have similar rights at sentencing. And certain factors, and usually the hearsay stuff doesn't come from the defendant; it's all coming from the government. So
the damaging hearsay for sure.
Yeah, damaging hearsay is certainly any mitigation stuff.
Well, the whole pre-sentence report is hearsay, not just hearsay, but it's layers upon layers
Right,
of
layers and
hearsay.
layers. It's just it's regurgitated hearsay.
Yeah.
It's the government giving a script to the PO. The PO just copies and pastes,
Right.
and here's the PSR.
And that
You know,
script, by
so
the way, was given to the government by the police in the police reports and the 302s and everything else. So,
right. So
okay.
yeah,
So, yeah.
but yeah, so something is there has to be some type of structure. I'm not, I don't have an exact structure for you, but
Yeah.
some type of structure. Doesn't have to be at the trial level, but certainly more than nothing, which is what we have right
Yeah.
now. Yeah.
My only other thing that should go on this wish list is, and it kind of is a callback to the extra point for acceptance. If a defendant challenges a suppression issue, that the idea of acceptance of responsibility is, I believe, fundamentally flawed. You get either 2 or 3 level reduction on your guidelines for acceptance of responsibility, but that is essentially like meaningless in and of itself, because anybody who pleads guilty, as long as they don't actually go into court at sentencing and say, I'm really not guilty, I just pled guilty because I had to plead guilty and this system
Right.
sucks, everybody else is getting their full measure of acceptance of responsibility. But you and I know from the work that we do, there's acceptance and there's acceptance. There's extraordinary acceptance.
Right.
And people have done things to make up for the wrongs, that the crimes they've committed, whether it's paying back restitution or you name it. And we can argue that under 3553 till the cows come home, but I feel like the guidelines themselves should, look at the aggravating and mitigating role adjustment in the sentencing guidelines. It's a sliding scale. It starts at like 2 if you have kind of a minor role, but then it goes up to, I think, 4 if you really have a mitigated role. So why not do the same thing with acceptance and just start out, with look at this, give us the baseline for just pleading guilty. And by the way, a lot of times that's the only consideration you're getting in a plea agreement is 3 levels for acceptance, which in and of itself is wrong. I feel like, because it's a given. It's like giving you nothing other, it's giving you what you're already going to get for simply pleading guilty. So I would like to see acceptance dealt with a little bit in more detail. Anyway, I think we've done our job today. And
so
then
I could go run out and look at the Northern Lights now.
You're going to go look at to go live on Facebook so we can see that. But
I am going to go live.
I have to say, though, when Mark called me up, he's like, he always gets, we got to do this on the guidelines. And my first instinct is, oh, my God, it's going to be so boring. But I think I was wrong. I think we actually had a very stimulating conversation about the United States sentencing guidelines.
I agree.
Lawyers and non-lawyers alike might be actually interested in. But the takeaway is, the proof will be in the pudding, which is make your comments, reach out to the commission. So again, October 17th is the deadline. They do want to hear from you. It does matter. I will put a link in the show notes. Please do it. And Mark Allenbaugh, my returning champion, my all-star, go watch your Northern Lights. And thanks again for hanging out with me today. And I'll talk with you soon.
Thanks, brother.
That's it for today, but before we go, I just wanted to take a moment and say thank you to you, the listener, for spending time with us today getting set for sentencing. Whether you're a lawyer, someone who could use the help, or maybe you're just a true crime buff who loves the inside scoop on how this whole thing works, I am so glad you're here, and I hope you keep listening. If you like the podcast, please do me a favor. Spread the word about Set for Sentencing and give us a rating and review on the iTunes podcast platform. It would really help. Last but not least, if you're interested in knowing more about what I do, mitigation videos, case consults, live teaching, on-demand educational content, books, articles, all of it, please visit www.dougpassonlaw.com. I'm Doug Passon. Until next time, hang in there. Wait a minute, that's a stupid way to sign off a podcast about sentencing. Hang in there. What's the matter with you, man? I guess they call that gallows humor. Sorry. All right. Well, I will see you next time on Set for Sentencing. Bye-bye.